Drew, one of the cases that we handle frequently is a slip and fall case. Why don't we talk about what some of the issues in connection with those cases are and what attorneys need to look out for?
Sure. Well, property owners generally owe folks a duty to maintain their property in a reasonably safe manner. That duty can vary depending on the type of visitor you are to the property, whether you're a business invitee or a trespasser for that matter. Property owners generally cannot maintain their premises in a negligent way, and they are responsible for trips, slips, falls that people might experience as a result of a defective condition on their property.
One of the things that comes up in those cases is whether or not a particular hazard is open and obvious or de minimis. Can you explain the differences between those two?
Sure. Well, an open and obvious condition is a lot what it sounds like. It's a condition that a reasonably prudent person would be able to observe and avoid if they were looking out properly. These are generally bigger conditions, so to speak. De minimis, on the other hand, is what that sounds like. It's a defect that is so small that a reasonable person wouldn't have experienced an injury as a result of it.
Another thing that comes up in these slip and fall cases, Drew, is the issue of notice. Can you talk a little bit about notice and what is required from our perspective when we handle one of these cases?
Notice of a defective condition on the property is crucial to your case. One of the things that we have to prove, and one of the reasons you want to hire an attorney, is to prove that the owner of the property or whoever's in charge of its management knew or should have known of that defective condition, and they failed to take reasonable steps in curing it.
You know, it's interesting because one of the things that when we handled these cases decades ago, nobody had video, but now they have videos, so you can see exactly when the hazard became present and whether or not whoever is owned or is in charge of the property knew about it and actually didn't do anything about it, and it presented a danger to the client.
I'm glad you brought videos up. Videos are very common in the slip and fall world. A lot of establishments are wired these days with cameras. The video proof can show how long a condition was on the floor, say it was a slippery substance, whether or not any employees walked past it. That sort of stuff can establish that the business knew of the condition.
Perfect, thank you.